schemes, corporate mergers and acquisitions, startups, compliance checks and audits, reorganization, recapitalization, and business restructuring. Nika James was very instrumental during the bank Holdco advocacy project, which resulted in the FIRS granting tax exemptions to holding companies of banks. Her drive for advocacy has resulted in her active participation with the Nigerian Insurance Agency, NIA, National Information Development Agency, NITDA, Pension Commission of Nigeria, PENCOM, and other regulatory bodies to create a conducive tax environment for Nigerian and foreign companies. And last but not the least, certainly not the least, we have Ngo-Martins of Okonmah. He's a senior associate with Aluko and Oyebode. Ngo-Martins leads and coordinates the firm's construction and infrastructure practice group. He is a construction sector expert with over 11 years of broad legal experience, including an in-depth exposure to arbitration and construction law. He has gained expertise in major standard forms of construction and engineering contracts, including the JCT, FIDIC, ICME, bespoke forms involving funder-led EPC and EPCM in various projects, including refinery, oil and gas pipeline construction. Ngo-Martins assists clients in negotiating construction and engineering contracts. He provides legal advisory services in implementation and delivery of construction projects, handles project claims and advises on a range of dispute resolution techniques peculiar to the construction industry, including contract adjudication, dispute boards, and arbitration. We welcome the three subject matter experts at today's virtual series. And before we continue, it is my pleasure to welcome the chief host of today's virtual series, the MD CEO of Accion Microfinance Bank, Mr. Taiwo additional Joda, to give the opening remarks. Good morning, Mr. Joda. How are you doing this morning?
Good morning. It's an excellent day again, Dolapo. And just before I go on, I'd also like to introduce our host today, Dolapo. Dolapo is the head of our legal team in Accion Microfinance Bank. And it's a pleasure to have Mrs. Dolapo Oladoyin hosting and steering the course of the ship today. Thank you, Dolapo. Yeah, the team here is really doing a great job. I'm so proud of every one of them. Their colleagues across banks and non-bank financial institutions, especially my ecosystem microfinance banking sector. I want to say one good morning to you, to our dear and warm facilitators, a beautiful morning to all of you. I would like to welcome you to the day 2 of our virtual session. Yesterday was day 1, and we had representatives from NIPS and also Udo Mandela Sagi. They shared insights on implication of global standing instruction, GSI, and the sandbox policies to the microfinance bank. Actually, one of the takeout of what we did yesterday was a letter initiated by the National Association of Microfinance Banks to the Central Bank of Nigeria to take a second look at that. And we're happy that we're making such an impact. So also, we're going to look at another interesting topic today, and I have Ngo-Martins of Okonmah, a senior associate of Aluko Oyebode, and Mrs. Makinde, partner Aluko and Oyebode, and Nika James, partner tax regulatory and people services at KPMG. They will be discussing today force majeure and stamp duties issues that are coming up for consideration. Like I said yesterday, for those of us who were with me yesterday, I had a situation on hand where a customer wrote through a lawyer, and I'm glad we have lawyers here today, saying that there is pandemic, coronavirus, and therefore they are declaring a force majeure on their loan. Is this applicable? How do we review this? They'll be discussing force majeure, and of course, the recently introduced stamp duties. I want to thank you, everybody. At Accion Microfinance Bank, I want to thank you for accepting, from Accion Microfinance Bank, I want to thank you for accepting to speak. I want to thank you for accepting to impact us. and I wish we have a very beautiful and wonderful time. I'm going to be on the silent part of it today as I hand over back to Dolapo Oladoyin. Thank you, Dolapo, once again.
Thank you very much, MD, for the opening remarks. So let's go straight to the presentations. Good morning, Ngo-Martins. Are you there to start the presentation on force majeure?
Yes, Dolapo, good morning. Thank you very much. Good morning, Dolapo. Good morning, Mr. Joda. Good morning, everyone. So today I'll be speaking on force majeure. I'll just go straight to my presentation. It's a very interesting topic, the issue of force majeure in the light of the pandemic we've been experiencing. I mean, suddenly force majeure clauses has become very topical since the pandemic. And there's a lot of question about what really is force majeure. What's the distinction between force majeure and frustration? You know, when can I invoke my force majeure clauses to suspend contractual obligations and all whatnot? I'll attempt within the next few minutes to give some insight about what force majeure clauses are. I think the first point to know is to note that force majeure is not a legal doctrine at all. It is basically a construct of contract. And what this means in very simple terms is that force majeure assumes the definition that you give it in your contract. So basically what the court would do in determining whether force majeure is applicable in any given case is to look at what the parties have stipulated in their force majeure clauses. So a party who is intending to invoke a force majeure clause, the first point to note is what the party needs to do is, first of all, to examine his force majeure clause to see whether the event he seeks to rely on for the purposes of declaring force majeure is listed in the force majeure clause. Typically, contracts adopt two different approaches. So some contracts have a closed list of force majeure events. What that basically means is that if the event in question is not listed in your force majeure clause, then there is no basis, no legal basis for you to declare a force majeure. So typically in the context of a pandemic, you want to look at whether a pandemic or epidemic is listed. And if it is not listed, then you want to look at other items that are probably listed, in which you can rely on, at least for the purposes of invoking a force majeure based on the fallout of the pandemic. So for instance, you know, government regulations in terms of business shutdown and all whatnot. But for the point about a closed list is that it must be expressly listed in your force majeure clause. The alternative approach is to have a non-exhaustive list of force majeure events. So what that means is that the contract will basically give an example of types of force majeure events and then give a broad criteria in which events, although not listed in the clause, may qualify as a force majeure event to the extent that it meets the criteria that is set down in the contract. But it's one thing to have the event in question described or listed in your force majeure clause. It's another thing to determine whether a force majeure can be invoked in such circumstance. And that's why the next point I'm about to mention is very important. The event in question must have the impact required by the contract on the project or contractual obligation. Now, what we tend to see in the course of these last few months is that typically parties look at their force majeure clause, and once they see pandemic, epidemic listed, they go ahead to issue force majeure notices without giving thought to determine whether the event in question has impacted the contract or project in the manner envisaged under the contract. Now, this is important because most contract provides that the event in question must have prevented performance. So what that simply means is that it is not sufficient for you to merely be experiencing difficulty in the performance of the obligation. Performance itself must have been prevented in some form. And the way the courts have sort of defined prevention in the context of force majeure is basically they've held that it would either be a legal impossibility or a practical or physical impossibility. So difficulty in the project, for instance, if the project has become or the contract has become unattractive in the sense that it's become more expensive, it's difficult to perform, probably you require more labor, more manpower, and all whatnot to perform it. So it's possible to perform, it's just that it's just that performance has become difficult. That is not sufficient to declare a force majeure. The contract, the law requires, if your contract, your force majeure clause provides prevention of performance, as most force majeure clauses do, it requires that performance must have been rendered impossible in some form. Again, even though, you know, there is some level of impossibility of performance in the contract, this must be balanced out against a party, the proponent of force majeure, which is the party seeking to invoke force majeure. There is basically an obligation on him to mitigate the effect of the force majeure. So a force majeure is simply not an excuse to do nothing. The court would, in such circumstances, examine the circumstance on a case-by-case basis to determine whether there was a basis to mitigate the effect of force majeure. So this is quite crucial, because if, for instance, performance has been prevented in some form, but the party seeking to invoke force majeure could have done something in such a way that the effect of the force majeure event could have been lessened or mitigated in some form, then the court will take that into account in determining whether or not force majeure has been declared rightly or wrongly in that particular instance. The next point to consider is you want to ask yourself, okay, what is the relief? What does force majeure entitles me to? And this is also very important, because typically you find that a party seeking to invoke force majeure will be thinking about excusing performance of his obligation under the contract. So usually, your force majeure clause will usually say, well, if force majeure is available, what it means is that it excuses performance, in the sense that it either suspends performance or it gives you the right. So some contract provides, in addition to suspending contract performance, some contract provides for a long stop date, after which either of the party will be entitled to terminate the contract. So that again is the relief. In some other contracts, for instance, in construction contract, in addition to these two measures, you will typically find that the party who is seeking to rely on force majeure may also be able to claim an extension of time. But in your usual general run of contracts, your service contracts and all whatnot, what you would typically find is that it allows you to suspend performance, and after a long stop date, that such a party would then be entitled to, can then exercise an option to terminate the contract if he wishes to. So that's the point about force majeure. It gives you a right, a substantive right to declare it, in which case, if you invoke force majeure rightly, you'll be entitled to certain reliefs. But the next question that comes to mind is, are there any procedures that have been set out in your contract that you must comply with in order to be entitled to the benefits or to the relief under your force majeure clause? And this is very critical, because sometimes your contract may require that compliance with that procedure is mandatory, in which case that may that may actually defeat your rights, basically, if you do not comply with the procedure set down in your contract. So usually, most contract provides that you must give force majeure notices. So some contract says, well, you need to give your notice within a set timeline, within a set time frame. Some other contract, in addition to providing for you to give a notice and give your notice timeously, would also provide that you give substantiation regarding the event itself in your notice. So what that means is, at the time of issuing your force majeure notice, you must have given sufficient details around the event that has caused you to invoke force majeure. In some other contract, in some contracts, some contract provide that in addition to giving substantiation, you must specify the relief you are seeking by virtue of that declaration of force majeure. In which case, are you seeking to suspend performance in the time being? and all whatnot. So those are the information that your contract may require you to provide. So what's the lesson from all this? I think the lesson from all this is to note that, well, again, before you declare force majeure, you need to look into your contract, because unlike frustration, which is a legal doctrine, force majeure is not a legal doctrine. Force majeure is exactly, it will assume the meaning that you have given it in your force majeure clause. So you must look at it. You must determine whether the event in question is listed. You must determine what's the required impact that your contract has specified. You must also determine what is what relief does it entitle you to, and what's the relief, what's the procedure that has been laid down in your contract to entitle you to benefit from that clause. If you do not meet any, if you do not comply with this provision, there is a real likelihood that when the force majeure clause is tested in court, the court may take a view that that declaring force majeure in the circumstances in which you have done would amount to a repudiation of your contractual obligation. So that's why careful thought must be given to these provisions before they are invoked. Thank you.
Thank you very, very much, Ngo. That was quite enlightening. I would like to take you back to a comment my MD made. Mr. Joda mentioned letters we received from customers. We have customers invoking force majeure clauses, even though it's not stated in the loan documentation. What do you have to say to that?
Yeah, that's a very good question. It's a very good question. What we found is that usually your loan documentation do not contain force majeure clauses. And what you would typically see in your loan documentation are MAC, which is material adverse change clauses, which effectively entitles the lender which entitles the lender in such situation to either to accelerate the loan by accelerate the loan, or basically refuse to lend any undrawn portion of the loan. So unlike force majeure clauses which excuse performance, that's not the case with MAC clauses. So as a practical matter, a borrower who declares force majeure on a contract will effectively be breaching his obligation, because there is no such right available to the borrower under such loan contract, basically. So that's clearly the situation. I mean, another point that probably follows from that question is, if the lender holds the big stick, basically, in such situation, in which case he can call in the facility as a result of the default of the borrower. The question is, will it be appropriate to do so in such circumstances? And this is very important, because, I mean, how do you enforce loan contracts in a pandemic? What we found in the last few months was that the courts basically were on total shutdown. So it's not even possible for you to approach the courts to be able to enforce such default. And also, if a party, if a lender intends to, for instance, appoint a receiver manager as a way of enforcing defaults, the question then is, how then do you sell or dispose of the assets? Typically, you'll be disposing it off at a loss. So from a lender's perspective, you may want to consider that even where a party defaults as a result of the prevalent situation that we saw during the pandemic, is it a wise option to enforce such default in such circumstances?
Okay, then the next question I would like to ask, before we go to the general question and answer session, what should a bank, a microfinance bank, consider when negotiating force majeure provisions in their service contract with the vendors?
I think this is a very good question. I mean, it's a no-brainer, the fact that going forward, we'll see in service contracts and in contracts generally, parties, when negotiating their force majeure clauses, will want to ensure that pandemics and epidemics are expressly stipulated as part of your force majeure events. So that's probably a given. Some other things to consider basically is, I mean, in my view, I think from a lender's perspective, you want to consider, you want to provide for some level of flexibility. So what we found was suddenly the economy was shut down because of the pandemic. The government rolled out regulation shutting down businesses and operations, which effectively meant that contractual obligations were practically suspended, or most contractual obligations. But all of a sudden, the economy, the government lifted the ban that was imposed. And what that meant was that businesses had to go back to work, contractual obligations were revived and all whatnot. So from a lender's perspective, you want to consider whether there is sufficient level of flexibility in your force majeure clause that allows you to invoke force majeure when the need, during a pandemic, but also at the same time, you can revive the contract once the economy opens up and your service providers can come back to business without any sort of disruptions or without any sort of so there is a seamless there is a seamless enabling of activity once the economy is revived. I mean, another point, just thinking about your question, another point, because the way the courts have defined prevention, they basically said, well, it means legal impossibility or physical impossibility. I mean, given the advancement of technology, and I mean, for some of us, this is the first time we're experiencing a pandemic. So maybe thoughts want to be given during the course of drafting your force majeure clause. Maybe it's important to define what you basically mean by prevention. So for instance, if it is possible to perform your contractual obligations remotely or virtually, then that cannot amount to an impossibility under your force majeure clause. So because there is, I mean, this is an uncharted area. The courts, there are very few or no guidance from the courts about how the court have dealt with force majeure clauses in the context of a pandemic. But perhaps it would be useful, given the line of authorities that have defined prevention in the force majeure context, to clarify in your contract that if performance is possible remotely, then that would not amount to impossibility. I mean, that will allow for contractual certainty for all parties.
Thank you very, very much.
May I also add, I mean, this is me thinking aloud. From the perspective of a loan contract itself, it's clear that your loan contracts do not contain a force majeure clause. Your loan contract will typically contain a MAC clause, a material adverse chain clause. But from a borrower's perspective, a borrower wants to have some level of certainty that if he's unable to pay his loan as a result of a pandemic, the lenders will not come down on him very hard. I mean, so while the lenders may retain their power and their rights basically to wield the big stick as at when due, perhaps it may be necessary to begin to consider how we are drafting our loan agreements to want to deal with a situation of a pandemic scenario where whether it would be useful for there to be some clarity about how would lenders in such context deal vis-a-vis in terms of their relationship with the borrower. Will contracts be enforced, or would a pandemic amount to an exception to enforcing contracts in the context of a pandemic? I mean, these are things to consider. I believe experts will consider this a lot more and take this on board.
Very well. Thank you very, very much, Ngo-Martins. I appreciate that. We'll pause on this section and move to the next topic on stamp duties. So please stay with us, Ngo-Martins, because we'll be going back to the general question and answer session where participants would fill their own questions. So I would like to invite Mrs. Ngo-Martins. Ngo-Martins, are you on? No, apologies. Nike James.
All right, good morning. I was wondering whether
Nike James. Apologies. My mind was still with Ngo-Martins and his enlightening session. Nike James,
right.
You're welcome. Good morning, ma'am. And we're ready for you.
All right, so good morning, everyone. Just give me a moment while I share my screen. Please confirm if you can see my screen.
Not yet. Yes, we can.
All right, then. So again, good morning, and I'll be talking to you about stamp duties and the issues for consideration as the National Association of Microfinance Banks. And very interestingly, I was with the Bankers Committee yesterday talking on this same issue. So it's a big front burner issue for all banks in Nigeria, whether deposit money banks or microfinance banks. And we probably have the highest risk in terms of stamp duties exposure compared to other industries. And I know the banks too are very odd, and they are going back to think about it, and they know that they have to do some advocacy also in their own cases with engagements with the CBN and others to ensure that they are not left with some untenable amounts of billions of liabilities. So now let's move forward and look through what some of the issues we're going to be talking about is. So I'd like to take you quickly through an introduction, first of all, to just give you a little background on stamp duties, give you some of the highlights from the stamp duty circular FRS recently issued and pronunciations made thereon. We see some of the big issues as it affects your industry, and then we talk about what next, what do you need to do in terms of resolution. And as we look at the background, stamp duties is an instrument that is used by governments the world all over to generate revenue. So there's nothing new about stamp duties. In Nigeria, it's been here for quite a while, since pre-independence in 1939 when it was promulgated. And when the compilation of the laws of the Federation was done in 1990 and 2004, it was also compiled alongside. So it is a valid legal piece of law. However, it's been deemed to have been moribund for a very long time because the Federal Inland Revenue was not really enforcing it. So ultimately, people only stamp documents when they feel that they may need to admit it in the court of law. So that was the impetus for people to stamp documents. And if you feel I'm never going to have a court case, people think it's at their discretion. So stamp duties was not enforced, and people are not also taking it very seriously. However, in the last few years, starting with 2016, we saw effort by the FRS trying to resuscitate stamp duties. And then there were some audits that were initiated, especially in the financial services industry, but everything fizzled out very quickly. Maybe they didn't understand it too, the challenges of doing the audits, they didn't have the methodologies, how do I look through the books, how do I determine the issue? So it fizzled out and it went off. But now with the Finance Act, I think it's finally put pace to it. It has fully codified in terms of stamp duties and actually legitimized and vested powers in Federal Inland Revenue Services to impose, charge, and collect stamp duties on instruments that are executed between companies or between a company and an individual or a set of individuals. So long as there's a company in the mix, then the stamp duties on those transactions must go to the Federal Inland Revenue Service. And what the Finance Act also did was to put paid to the controversy of whether stamp duties, some of the stamp duties should be collectible by NIPOST or should be collectible by FRS. I probably know that FRS has since launched its own adhesive stamp. So going forward, you can no longer use NIPOST stamps. Even for stamp duties that are on flat rate, you have to use the FRS's own stamp. I think it's 15 naira stamps they have each that has to be used. Now again, before I leave the background, just remind us that stamp duties originally was meant for fiscal documents. So obviously, as at the time pre-independence, when stamp duties came up, there were no electronic documentation then. But with the Finance Act also, what it did was to expand the scope of stamp duties to also cover both physical and electronic transactions. So that's why it's become very topical, and that's a pressing and burning issue we need to address. And as I was saying earlier on about stamps, stamp duty actually has two types of rates. What we call the fixed rate or nominal rate, which is some flat amounts of money that you got to pay, and the ad valorem rate, which means the rate is variable and it is probably a fraction of the underlying transaction that is codified in your agreement. So we bear that in mind. So now let's look at some of the recent some of the recent developments we've seen in our environment on stamp duties. Like I said, FRS was not very keen on stamp duties previously, but they've woken up fully to it. And you probably know that earlier this month in January, first week in July, there was the launch of the Interministerial Committee on the Recovery of Back Duty Stamp Duties. It was launched in Abuja, and it was a very big affair of the government. We had from the presidency, from the National Assembly, a lot of people were there. I think the head of National Assembly was also there. And there it was said FRS has this committee which is driven to recover stamp duties, and other government parastatals will support it in the execution of its work. So CBN, NIBSAs are firmly also enmeshed in this committee, and there's a big drive and determination to recover stamp duties. It's also important to note that we're in a pandemic. There's been a lot of palliatives given, and you would have ordinarily expected that, okay, those palliatives would mean government will be more considerate in terms of its revenue generation during this period. And I think they start with the pandemic when it started, that was the consideration. In fact, there were considerations then that the budget for stamp duties for 2020, which was earlier set at 400 billion at the beginning of the year, that will probably be moderated to 200, 250. But after that launch, and government saw the untapped sources that FRS has brought to its attention, they said stamp duties is now a new oil money, and that we should be making 1 trillion annually from stamp duty. So the big question is, where is the money going to come from? Which industries are at risk, and what instruments are at stake? And you know, the more we talk about it, we realize that the financial services industry and the banking industry specifically is actually in the eye of the storm. The biggest issues affect us, and we need to take action so that we are not left with a bag of huge liabilities that we have to deal with. And you know, so that we understand where the government is excited and looking through making a whole lot more from stamp duties, they did a comparative analysis of the stamp duties revenue FRS generated in 2019 for the first 6 months in 2019 vis-a-vis the first 6 months in 2020, and the growth in the revenue was 1,000%. In the first 6 months in 2019, FRS generated 6 billion. And then in the first 6 months in 2020, they generated 66 billion. So immediately it went out of the roof that, oh, we're in a pandemic, there's an issue. Rather, government is very excited now that they've found a new source of wealth, and they intend to exploit it to the ultimate. So we have to get ourselves ready. For a number of players, we don't even know what our exposure is, either as individuals, as an industry, and this is why we need to wake up quickly. We can't really afford for the government to do audits, determine some huge sums of liability, and at that time we begin to react and defend ourselves that no, this cannot be true. The time to do action is now, before those liabilities are crystallized, and getting a redress becomes an issue. So we're going to take you quickly through some of the areas that we see that are controversial, and some of the things you also need to know so that we can get our houses in order. Now, like I said, the Interministerial Committee was launched earlier in this year. But even during the pandemic, FRS was very active and issued a series of circulars, which was pursuant of the Finance Act that came out in January. I think specifically it was in April that the circulars came out, and one of them was dedicated on stamp duties. And broadly speaking, there are two types of instruments, and that's how we take you through it. There were conversations around electronic instruments and then on physical documents. So I'll just start with electronic and confirm again what we have there. Some of it you already know. So for instance, the payment of 50 naira stamp duties on electronic transfers above 10,000 naira, we know that already. So that was clearly from the Finance Act that gave it the force of law that becomes valid. So the question you would ask is that we've had these electronic transactions, 50 naira, for the last 5 years, since 2016. So if it's just coming into the Finance Act, what gave it the force of law in the last 5 years? That's a huge question. But the Finance Act didn't stop only on those electronic transfers. It has also brought all manner of receipts, so long as in electronic form, under the ambit of stamp duties. So going forward, even informal transactions between two parties, whereby there's a transfer of money or there's a payment for goods, and you issue a text message, I confirm receipts, or a WhatsApp message, that is also dutiable at stamp duties rate. So I think that's very controversial, or rather, let me say it's the practicality of collection on stamp duties on such other electronic transactions and instruments is very doubtful. But we believe the ones FRS can track and come after are those ones that are done within the confines of the banking institutions, that have evidence and tracking, whether because they were done on ATM, POS, or deposit in bank accounts. So that is what we'll have to really concern ourselves with and ask ourselves how we deal with that. So I'll come back to this issue in a little while and talk more about this controversy in terms of the last 5 years. Now let's look at the fiscal documents. In the FRS circular also, there are a number of fiscal documents that were showcased and the stamp duties on it. And I dare say most of them also applies to banks. So like I said, we are really in for it and we need to get our houses in order. Now, it would have been nice if FRS merely stated what was in the Stamp Duties Act to confirm in terms of the rates payable, but we think they went ultra the Stamp Duties Act. And that's where we need to pay attention so that we don't unduly pay stamp duties where we don't have to. And I like to start with the last one. I know I have 7 items there. With the 7th one, I highlighted it. Because in the circular, they say general agreements for all contract agreements that is executed with one party to the other that is now dutiable at 1% of the contract value. And it's interesting because it's not in the Stamp Duties Act. And this is one of the major sources that FRS, there's been all manner of news, 1% contracts, stamp duties on contracts. And the question is, where's the legal basis? It is not in the Stamp Duties Act. And that is where we feel it's extremely controversial. And as industry players, we can't just sit down. We need to do something about it. Now, there are other instruments which are indeed in the Stamp Duties Act, but the representation by the FRS has been inaccurate. I guess the biggest of that has gathered news and is still trending on social media is on rent and leases, whereby FRS came out strongly and said 6% stamp duties on leases, but they weren't quite right because the principal legislation provided for a range of rates depending on the tenure of the lease agreement. And for most of us, we're not going to rent apartments and pay leases beyond 3 years, at a glance. And the law actually was very considerate. It gave that between 1 and 7 years, you only pay 0.78% of the value of the rent as the stamp duties. And if it's between 7 to 21 years, it's 3%. Leases above 21 years have stamp duty rate at 6%. However, FRS went out saying that 6% stamp duties on all leases. And after there was a lot of storm and backlash, they had to come out and they clarified that no, for rent, it's actually in this 0.78% category. Please confirm if you can still see my screen. It's gone off on my side.
No.
Okay, I don't know what happened.
I can't see your screen either. But we'll check that at the back end.
Okay, thank you very much. So I'll just continue the conversation. So FRS has to retrace its steps in terms of leases to confirm that 0.78% indeed arises. And it goes on for a number of these instruments I have on this slide. Mortgages, again, the law provides for a range of rates from 0.075% to 0.375%. But in the FRS circular, it was just the topmost 0.375% that is written. So that is why, because of a lot of controversies around it, and because of the nature in which Stamp Duties Act is also written, there is need for some specialist review to determine what transactions are we doing, what are the real rates that are applicable. There are also exemption clauses in the Stamp Duties Act to determine whether on our transactions these exemption clauses are applied. For instance, sale of goods is exempt from stamp duties so that we are not unduly paying stamp duties. So please, FRS circular and all publications that they've had in the papers, public notice, please take them with a pinch of salt because the rates are not exactly the rates are not exactly accurate. So given these issues, the question we then ask ourselves is, what are the key burning issues, especially as NAM, that we need to pay attention to? And we think they're in 3 areas. Sorry, I guess my screen is no longer sharing, but I'll just keep talking through it. Or let me see if I can still share the screen.
Yes, ma'am. You can try again.
Okay.
Let's.
Okay, I think please confirm when it comes up.
Yes, it's back up.
Okay, very good. So as NAM, what are the key areas we think we need to focus attention on, given all the varied issues around stamp duties? And we think there are three. One is on the fact of the extraneous rates, because this is not company specific. It affects the group of our companies, and the single major one of it is the 1% stamp duties on contract. And the question is, how can we push back on it? We know there's the intention by FRS to actually codify this into law. And there's a little history behind that 1% stamp duties on contract. Like I said, it's not in the Stamp Duties Act. But many of us may have heard about the JTB harmonization schedule, which actually came out in 2002 and was purportedly amended the Stamp Duties Act. But it couldn't have, because in the Act itself, for you to amend it, it has to go through a legislative process. It has to have gone to the National Assembly and sought approval, and it's then that becomes a legislative instrument. And the first instrument that has amended the Stamp Duties Act to date is the Finance Act. So in reality, maybe the JTB harmonization schedule is just an intent, expression of intent, but it has not yet amended. We also have it informally that maybe FRS is trying now to get the harmonization schedule through the National Assembly and get it approved. But until that is done, it is not the law. So the issue on this 1% contract fees is it should not be applied retroactively. Go through the due process, get it approved, and it can then apply on a going forward basis. So I think that is where we have to use our might as an association to ensure that that is not unduly applied on our members. And the second has to be stamp duties on electronic transfer. I was mentioning that earlier on in terms of Finance Act codifying the 50 naira just in this January 2020 when it came out. So what about the last 5 years when CBN mandated that we pay 50 naira or banks must charge their customers 50 naira for any deposit that was above 1,000 in their account? And during that period, there was also a court case that said it was not legal between StanChart and the other entity. But we know that banks did not stop collecting it. And for a number of them that we spoke to, they said, well, FRS issued a policy on this and FRS never withdrew their policy. So they still have to go by CBN issued a policy and never withdrew the policy. And that since CBN is their major regulator, they have to go by the words of CBN. Okay, but the question is, what if we have not been collecting? What if we had obeyed the court case that came out and we haven't collected it? That's number one. Number two, is the 50 naira during that period legal? It was never in the Stamp Duties Act. So we have to take an action. We also had this kind of conversation. I had it when I spoke with Bankers Committee yesterday. And they said, yes, they know they have to do some engagement with them, maybe some trade-off with CBN, saying, well, maybe the reality is that that money should actually be refunded to banks, but they know the government is not going to refund it. So maybe some pushback with, well, you don't have to refund, but don't come and audit that same period. So I think we also need to do something as NAM, and I think in our own case, because we are for financial inclusion. So the burden of 50 naira on the kind of customers which are actually the low income earners is actually putting a huge financial burden on them. So we probably have a stronger case to make a case that yes, it's not legal, and based on the virtue of the kind of our customers, really should we be having this additional charge. And it's interesting to note that before the Finance Act amendment, what you had in the Stamp Duties Act was that on receipts that had some stamp duties rates, it says savings accounts were exempted. But unfortunately, when the Finance Act came out, it said on all accounts, you charge 50 naira. So the question is, perhaps savings accounts should have continued to be exempted, which is the account that most of our own kind of customers actually maintain with us. So we think there's a case that NAM should be able to make on its for its members in terms of a relook, in terms of FRS doing an audit for the past 5 years. Really legally, it's from January 2020 that we know that 50 naira is applicable. And on the last major point that we think should be a focus for NAM is on the demand for stamp duties by state governments. We are aware that for many of our banks, especially outside of Lagos, the state governments come actively after them on stamp duties. And the argument, especially on electronic transactions, and the argument the state governments make is that if there's a transfer of money, say for instance, between myself and Dolapo, that we are two individuals. So the stamp duties on that transaction should actually go to them because there's no corporate entity there. Remember that we said this, the Stamp Duties Act says so long as there's a corporate entity in the mix, then it goes to federal government. But then the argument is, can Dolapo and myself merely transfer the amounts between ourselves, or we actually use the bank that we are also holding accounts with to do it? So how do you define the bank in that mix? Is it a party? Is it an agent, or what have you? Currently, we know there's a court case. A number of the state governments have taken FRS and federal government to court on this issue, and it's at the Supreme Court level. So we are all eagerly awaiting the outcome. But we believe until there's an outcome, there should be no payment to the state government, because what you have is it goes to the federal government. So I think we should bear that in mind. And any attempt by any state government in the time being to come after us for this, we should resist it. Even if you have to tell them we'll go to court on this. We know of a few banks that have taken them to court, and the case was in abeyance since then, and nobody's taking anything. So let's bear that in mind, and let's protect ourselves and ensure we are not unduly exposed. So given those three issues, I'll just quickly confirm them through. So that is what we need, association. I think we need you to focus strongly on it, on the advocacy drive with the FRS, Ministry of Finance, CBN, Presidency, in terms of the retroactive application of stamp duties, 1% contract rate and 1% stamp duties on contracts, and all other ones that are not in the Stamp Duties Act should not be enforced. We believe you need to do a collaboration, like I said, amongst yourself. Let's not break ranks, because sometimes what state governments do is that, oh, they tell you some other banks are paying, so why are you complaining? So let's maintain a common stance and tell state governments until the court case at the Supreme Court is decided, the stamp duties are going to the federal government, so that they should all wait. And finally, we need to either mount an advocacy or perhaps a legal action in terms of stamp duties on electronic transactions, the audit for the last 5 years. I delicately put it, do we want an advocacy is more subtle, and it's always, I believe, the first way to go, really, because you may achieve a lot without you actually drawing the lines of battle. But if advocacy does not work, and if we actually evaluate and say we have potentially huge, horrendous amounts of liability, I think the way to go is to then take it on a legal case in terms of what really is legal. Was 15 naira legal in the past 5 years? So on that note, I bring my presentation to a close. And it's just to remind us that even though we are an association, we are still also individual banks. FRS is coming for audit of both your fiscal documents and electronic transactions. So we need to get our books in order. Please ensure that you are reviewing in terms of your fiscal transactions, conducting pre-audit checks, and also getting yourself ready for when these audits are done by FRS. Again, a proactive check will enable you to find out issues you have in your books and take remediation action. Some of it is to claw back from your customers, and what have you, or even pay some that you think is reasonable, so you don't have to suffer penalty and interest charges of 30% when audits are indeed conducted. So on that note, I bring my discussion to a close, and I hand over back to Dolapo. Thank you very much.
Thank you very, very much, Nika James. This is a very awesome presentation and quite enlightening, because you've thrown so much light on the issues around this electronic transactions, stamp duty, exposures, unplanned exposure from this JTB harmonization rates that came out recently, which is inconsistent with the Stamp Duties Act. Thank you very much. Before we take questions from participants, can I crave your indulgence for us to take Oghogho Makinde? She's going to take it from the legal perspective and throw more light on the stamp duties payment. Thank you very much. Mrs. Oghogho Makinde, are you on? Good morning, madam.
Good morning, I'm here.
Okay, so we're ready to have you.
Yeah, I think we can just shut down now, because I think Nika did a great job of covering the field. So there's really nothing else to add. I remember having a webinar a couple of weeks ago. Ngo-Martins, I remember we did with some UK law firm, and we're talking about government revenues and challenges and what corporate entities should expect. And then the UK law firm dealt with it from an international point of view, and we're talking about, investigations anti-money laundering. And I said to the participants that, look, we'll take this from a Nigerian perspective. We know what's going to happen. There's going to be a shakedown. There's not going to be any new laws, but the government is going to come and start enforcing laws that, you know, everybody did not even realize were in the statute books. And I think we can actually see that happening now. We are going to see a stricter enforcement of all types of charging and fining and payments and regulations, and we can see that now. So Dolapo, I'm ready to start. I think that we can just keep this page, and Nick has already dealt with this very, very extensively, and we can also skip this page to tell you the truth. So this is, let me see, this again, Dolapo, you know, I think we should skip this as well. I don't want to go over what Nick has already dealt with in a very, very extensive way. I'll just talk very briefly on the treatment of electronic documents from a legal perspective. As Nike had said, you know, because we had such an old stamp duties law, it didn't have in contemplation electronic documents when it was passed several months ago. What we had was a provision that said that if agreements are signed outside Nigeria, they become dutiable 40 days after they are brought into country. And what has happened is that the Finance Act extended the definition of documents to electronic documents. So there's a notice that the FRS issued in April. It wasn't as interesting as this current one because it didn't deal with leases. But it basically provided some more outline on how electronic documents will be considered as having arrived in Nigeria. And it provides clarity, which we lawyers actually like. So if it is, for instance, saved in a saver where it can be retrieved in Nigeria, or if it is saved in a device, either a movable device or in a computer or in a laptop, and the laptop is brought into Nigeria, then that document is deemed to have been brought into Nigeria. And we thought that this was an excellent way of providing clarity on a very modern issue. And a couple of years ago, we did an overview of our Evidence Act, and electronic documents are now admissible in evidence in Nigeria. So for us, this was a natural progression for providing more clarity with how to deal with electronic documents and bringing Nigeria into the 21st century. Next slide, please. So this also just more information on how the FRS will now treat electronic documents received in Nigeria and apply the stamp duties. And it's already happening with the aid of technology. For instance, if you wanted to incorporate a company now and all of your members that we used to take to stamp at the stamp duties office physically, you actually don't need to do that anymore. The stamp duty is actually paid online, the stamp endorsement is done online, and the CSA will actually issue you a receipt, of course, in collaboration with the FRS to show that the document is has been stamped. So stamping of electronic documents in Nigeria is has arrived, is here to stay, and I think it is a welcome improvement in the law. Thank you.
Thank you very much, Ms. Oghogho Makinde. We have someone special in our midst as well. Mrs. Yinka Edu, she joined us yesterday at the session on Sandbox and the global standing instruction.
I missed that.
I'm telling you, it was a fantastic
session.
I'm so sorry, it was a fantastic session, and I'll share the materials and the recordings with you. Okay. Mrs. Yinka Edu, are you good?
What a
good
surprise.
Afternoon.
Hello, everyone.
Good morning, Yinka. Good morning.
Good morning. I had to come in and support my ladies. Oghogho and Nick. Well done, ladies.
Okay, so Yinka Edu is a partner with Udo Udoma and Bello Osage. She's also a subject matter expert, and we're going to pick her brains this morning during this session. So, Mrs. Edu, thanks for being on standby. And we'll be calling on you shortly to share your views as well on these topical issues. Thank you, ma'am.
No comments.
Okay, so we'd like to go to the question and answer session. The chat box is open for participants to type their questions, and if you want to speak up, we can always unmute you, just raise your hand. The first question will go to Ngo-Martins on force majeure. what exactly would we call the extent of a party's obligation to mitigate the effect of a force majeure? Now, I would like to clarify, this has to do with service contracts, where a service provider is to provide particular services within a project timeline, and then suddenly we as microfinance banks now get instances where a service provider now invokes the force majeure clause on grounds of a government lockdown, with the fact that the project needs to be completed as planned, but we now have this issue of invoking force majeure. What options, what remedies are available to us as a financial institution? Ngo-Martins?
Yes, thank you very much. Yes, so basically what you have is, you have a scenario where, just to clarify, the service provider is invoking force majeure, or it's the bank invoking force majeure?
It's the service provider invoking it. So the option, what remedies are available to us as a bank?
Right. So basically, when you talk about mitigation and force majeure, this is the broad principle. The broad principle basically is that a party who is seeking to invoke force majeure, it is not sufficient that performance is prevented. The law would expect, and the court would also examine, whether in the context of that project or in the context of that contract, there are certain steps that that party seeking to invoke force majeure could have done, either to eliminate the force majeure event or to lessen or mitigate the effect of the force majeure. So in such situation, what the law expects of such individual is not only to consider his own commercial interest, but he is required to consider the commercial interest of the counterparty to the contract. So in doing so, the question then is, if for instance, I could take certain measures, if for instance I could take certain measures to lessen the effect, to what extent? If in taking those measures, it means that I will be spending twice the contract sum, or it means that I will be going outside the bounds of the contractual provision in order to mitigate the effect itself. The question then is, to what extent is that the obligation on me to mitigate the effect of the force majeure event? What is that extent? And again, you still have to go back to your force majeure clause, because like I said during the course of my presentation, force majeure is what you say it is in your contract. So typically, what you tend to see in force majeure clauses is there are some clauses that says, well, in exercising your obligation to mitigate, there is a best, such a party is required to make his best effort in trying to mitigate the effect. Other clauses says, well, all you need to do is, it's a reasonable effort obligation on you as against the best effort obligation on you. If you have a best effort obligation on you, that's a very high threshold. So the law, the court in such circumstances will be looking at your capability to actually mitigate the effect of the event itself. And then the court will be asking itself, have you, in the light of your ability, have you made the best effort available to you in mitigating those circumstances? So that's sort of more of a subjective test. But if there is a reasonable endeavor obligation on you with respect to mitigation obligation, the court will take a more objective test to say, well, given the peculiarity of the project itself and given a reasonable man's test, have you done what, from a reasonable man's point of view, is required of you in terms of your mitigation obligation? Once that has been done, then the court will take a view that you have actually done all that was required of you in invoking a force majeure. So basically, this is the two broad tests that the court will basically apply its mind to, which is your best endeavor obligation and a reasonable man's test in determining. While the best endeavor obligation is such a high threshold, the reasonable man's test is a much more lower threshold that you must comply with. So I think the answer to your question is that it depends on your contract. It depends on your force majeure clause, and that would basically inform what a service provider seeking to invoke a force majeure, invoke force majeure, the extent he is meant to consider the bank's commercial interest, and what extent he is meant to go in lessening that effect of the force majeure, basically in deciding one way or the other.
Okay. Thank you very much, Ngo-Martins. Mr. Igbe Samuel would like to ask a question. I will just mute him now.
Hello.
Yes, hello, Mr. Samuel. Good morning.
Good morning.
Please go ahead. Yes. Thank you for joining.
I want to find out. Yeah, you are welcome. The first thing is, I want to confirm something with respect to this stamp duties. One, customers usually make deposits to my correspondent bank, and in turn, I will credit them with me. Now, what I do is, first of all, I'll take the stamp duty I was charged and charge to them. Am I expected to charge another stamp duty internally on such deposits? And would it amount to double charges to our customers? Because sometimes, you know, definitely not all banks have uploaded microfinance bank on their NIP platforms. That is one particular thing I want us to, whether we could have clarification on, would it amount to double charges to stamp duty for the client, for the customer? And would it amount to us now, like, well, maybe when FIRS come to our bank and say they want to do audit, would it amount that they will not ask us to pay for such transfers that we actually did not charge stamp duty on? Thank you.
Make you a subject of wisdom and stupidity.
Thank you, Mr. Samuel, for the question. Who would like to assist us with this? Nika James, would you like to?
Thank you, Dolapo. Yes, if I got your question well, Mr. Samuel, it's in fact, it's about stamp duties transaction that actually involves a correspondent bank. So that means that instead of it being movement from one account to the other account, there's an intermediary bank who receives it and then it flows through. That's one of the challenges we're having in terms of what do you do with those kind of, because banks have also reached out to us that, you know, right now with the Finance Act that says all accounts are liable to stamp duties. But then the question is that there are some intermediary accounts, there are some temporary accounts that are used to transit funds. Based on the strict reading of the wordings of the Stamp Duties Act, then those accounts too should pay stamp duties, because it says that stamp duties is on the receiving account. So any account that receives money above 10,000 should, so even if it's an intermediary. And we think that those can be further areas that we need to then take as an industry, as we see how big this issue is, that further clarification can be sought. And hopefully in the next amendment to the Finance Act, for instance, maybe there might be clarifications that actually addresses for intermediary accounts of this nature. But currently, based on the Finance Act, it would appear that you'd have to double impose stamp duty, so to speak.
I agree with Nika's comments. Sadly, that is one of the potentially unfair implications of applying the stamp duties, because it does say for each account, so there's no distinction.
Thank you. So we'll go to the chat box and take some questions. The first one relates to force majeure. Ngo-Martins, where an organization wants to invoke a force majeure, what is the procedure to start with?
Notice. I think that's pretty much what you see in most force majeure clauses. Typically, you will find. So I mean, from a legal standpoint, I think the first thing is, first of all, you need to determine whether you have a justifiable basis to invoke force majeure within the peculiarity of your contracts or the project in question. So you want to ask yourself the questions that I basically posed in the course of my presentation. You want to ask yourself, well, is the event in question listed in my force majeure clause? I think that's the first question you want to ask yourself. The follow-on question to that is, if it is listed in my force majeure clause, does it have the impact required by the contract? So typically, your force majeure clause will provide two types of impacts. The first type of impact is the impact which I call the prevention impact, or the prevention clauses, which basically would say it must result in some level of impossibility, either legal or physical impossibility. The second type of impact that you see in some force majeure clauses, in a lesser case though, is what you call a hindrance obligation. So even though it doesn't require legal or physical impossibility, it requires some level of hindrance. So if, for instance, it delays the implementation of the obligation, so those are hindrance clauses or difficult clauses, difficult type clauses, basically. So you want to look at the impact. And then when you've looked at the impact, for the party seeking to invoke, you want to ask yourself, in terms of my duty to mitigate, have I, in this circumstance, is it such that I would, in the eyes of the law, I have fulfilled the duty required on me to mitigate the effect of the force majeure impact, or basically. And if, in light of everything, you've balanced it against your duty to mitigate, and there's still a justifiable basis to go ahead to invoke the force majeure clause, then you then have to come to the procedure, which is notice. So once you have a good basis, and then you have to look at notice themselves. What does the contract say regarding procedure? Notice, number one. Secondly, is there a time for the notice? What time am I required to serve the notice? Does the contract requires me to provide some level of substantiation in terms of giving some basis why I'm seeking a force majeure? And if it does say I should give substantiation, you want to also find out whether it provides that I should state specifically the relief I am seeking in that notice itself. So these are, roughly, these are the things you need to consider in invoking a force majeure. Maybe the other thing that your contract would not say to you is, from a commercial context, you want to ask yourself whether it makes commercial sense to invoke for force majeure. You want to ask yourself, are there options, alternative options available to me? So this is a very good question, because what you tend to find during the pandemic is most parties, once they find that the event is listed in their force majeure, they go ahead to start giving notice in order to in order not to forfeit their rights under the contract. But you want to ask yourself, well, are there alternative options? The pandemic is something that's basically unprecedented, and also there's little guidance in terms of judicial authorities on how the court will interpret these force majeure clauses in light of the pandemic itself. And what we tend to see, and what we tend to encourage parties, is to try and see how, if there's some form of collaboration by which parties can sort of reach a consensus understanding on how to manage things. So you try and find a solution outside the provisions of your contract in trying to forge business continuity and relationship, basically. So I think these are the broad things to think about before determining whether or not to exercise your legal rights in invoking a force majeure.
Thank you very much, Ngo-Martins, for that clarification. I would like to invite Mr. Bunmi Ogunrinde. Mr. Bunmi Ogunrinde is the chairman of the National Association of Microfinance Banks, Ogun State Chapter, to ask this question.
In return.
Mr. Bunmi Ogunrinde.
Yes, please.
Yes, sir.
Hello.
Good afternoon, sir.
Good afternoon.
Good
Are you
afternoon, sir. We
hearing
can
me?
hear you now. Please, yes, we can. Please go ahead with your.
Okay. Yes. As I was saying, the last question responded to by your co-host concerning transfers received on behalf of our customers through our correspondent banks. I think maybe she didn't get the questions properly. What he's trying to say is that we receive these customers on behalf of our customers. We receive these transfers on behalf of our customers through our correspondent banks, and the correspondent bank debit our own account. Then we subsequently recover these funds from the customer's account. So I think the transfer should have ended there. But implying that we have to debit the customer again at our own end amounts to double debit. So I want further clarification on that, please.
Okay, thank you very much, Mr. Ogunride. And yes, when I heard the question at the beginning, I had correspondent bank. I wasn't quite sure, but towards the end, I thought I got it well. But now that you've shed more light with it, if it's simply an amount that you receive on behalf of your customers and then you transfer it to your customers, in that case, you are simply just taking that money through you to your customers. No, we don't believe that stamp duties will be applicable there. So if I give an example that perhaps maybe I'm expecting money from offshore thereabouts, and it goes through you as a correspondent bank and eventually lands into my account, I think in that instance, yes, just simply providing your normal banking duties of helping to move money around, and that is not a matter of a deposit that entered your bank as if you received it. So I believe that will be excluded.
Yeah, thank you very much.
Okay, thank you.
We'll go back to the chat box. We have a question on stamp duty. Is a microfinance bank going to charge stamp duty on transfers of its customers through its conventional platform?
Okay, I guess, okay, I've unmuted myself. Well, I think we've discussed this already. If there's a transfer, now it depends. Now, if you have a customer, a microfinance bank customer has received monies into its account with a microfinance bank, there'll be stamp duties applicable on it. So it depends on what you mean exactly by the transfer. In the case Mr. Ogunride clarified, that is, the bank is acting in its normal function and as a correspondent bank, so it's not the receiver of that money. But however, if money comes into your account and it's received, then in that case, you would have stamp duty. So except we have further clarification on that, we would say that stamp duties will be applicable in that instance.
Okay.
Yes.
And the next question is, I want further clarification on the 1% contract clause. Does it imply that every loan offer letter attracts a 1% stamp duty?
Okay, maybe I should come in. All right, now, the 1% contract clause is excluding instruments that are specifically listed in the Stamp Duties Act. So things like loan contracts, mortgages, leases are specifically mentioned. So for that basis, they are not covered under the 1% contract FRS has said. So 1% contract will then apply to any other instrument that has not been specifically listed. And interestingly, the Stamp Duties Act also provides for this class of instruments, because it does say that if an instrument is not specifically listed, then stamp duties will apply. But you know what rate it is? It's a very nominal rate, 15 kobo. So FRS deeming to use 1%, which comes from the JTB harmonization schedule, which has not been passed into law yet, is not legal.
In fact, if I may add, this is actually one of the more dangerous provisions of the FRS notice, and it's clearly lawmaking by the back door, because it could actually apply to any document whatsoever.
Next question is, during the lockdown, organizations in the essential services sector were active but defaulted in their obligations. Would it be right to insert a clause to mitigate force majeure in loan offer letters going forward?
I don't think so. I don't think it's going to be right to insert force majeure in force majeure clauses in loan contract, because what you tend to what you basically achieve by doing that is to basically give borrowers the option to default on obligation. So that would be quite dangerous from a lender's perspective. So I don't think that's the way to go. Maybe what potentially would happen, like I said, I mean, the whole thing about the pandemic is unprecedented, basically. And what I think what banks probably found is, I mean, they were at the street in terms of, you know, borrowers are defaulting on obligations. Do we go ahead to enforce the loan contracts, or do we, you know, do we take a more commercial and more considerate approach, which I think is the best way to go. But in certain force majeure clauses, we'll be taking it to a whole new level to give borrowers a legal right to default on loans, which is not the best option in my view.
If I may add, I think that for the lenders, your material adverse clause would actually be the best way to continue to protect yourselves, because as Ngo-Martins has said, if you now give a force majeure provision, which gives the borrower, when impacted, the right to be able to suspend or be relieved from performance, that is actually more dangerous for lenders. And you do want to retain control such that you are able to make a determination as to whether an event has occurred, which is important enough to be able to terminate and call on a loan.
Okay. I have another question. As an MFB, this is directed to Ngo-Martins. What will you consider as the start point or box checking to determine compliance level with the Stamp Duties Act? What role can KPMG play in this regard? Second question. And is there a way this can be done in a pocket-friendly manner, considering the fact that we are small microfinance banks?
Okay, thank you, Dolapo. It is James, not Ngo-Martins. All right. Okay, so
you should find her for each time she does that.
I apologize, man.
And I will appoint Oghogho as my lawyer in that regard.
Happily. I'll charge both sides.
Wow. Okay. So on the Stamp Duties Act, what's your start point? You need to do a health check, like we called it, which is another word is a diagnostic review, to look through all your transactions that will be impacted by stamp duties, and then determine your compliance over the last 5 years, and then determine what the exposures are, and then if you do it with professional help, you know, it can be determined what can you do as remediation activities that can actually reduce and manage those liabilities, opportunities to claw back from customers, are there other things? Or sometimes you may have some unique transactions, or maybe your transaction, it may be liable to stamp duties, but there are some exemption clauses as well. Perhaps it qualifies for one of those exemption clauses. That is where professional help actually helps you to determine and you can take the right action. I remember just recently, like a year ago, there was a conveyance of sale transaction that a major bank did. And the stamp duties was extremely huge. It was almost £1 billion. And, you know, we had to help them look through it. We engaged with their FRS. And when we checked the details of the transaction and the manner in which it was, you know, carried out and the parties involved in it, it actually was one of the exclusion clauses, exemptions provided in the Stamp Duties Act, and we engaged with FRS, formal writing, submitted the contract document, and we got their confirmation. They said, on this document, it should be stamped at no kobo, and it wasn't stamped. So that's where oftentimes doing it with help can help you, especially if it's professional help, can help you determine. So the right point to start is with a diagnostic review of your records to determine what you can do. As KPMG, of course, we'll be very happy to help you. In terms of we're expensive or fees, I don't understand that, but we can have a conversation after this, and I'm sure we'll be happy to meet you and support you. We already work with a number of people, and we don't like pricing to be an issue where we have differences in opinion. So we'll be happy to have further conversation with you.
Thank
And
you
Nika,
very
I
much.
think we should also, sorry, Dolapo. I think, Nika, we should also add the fact that, as you said earlier, advocacy is really important in this, because some of these stricter enforcement of these stamp duties and finance provisions are actually also impacting on other very good government policies on financial inclusion and all of that. So you should all also really put the advocacy aspect of things at the top of your list and approach this on a global basis. And of course, experts like KPMG would now assist on a global side.
Absolutely correct. Thank you, Oghogho.
So we move on to, there's a question on force majeure. Does it then mean that where force majeure is not stipulated or defined in the contract, natural occurrence or pandemic, for instance, cannot be a ground for consideration?
Before Ngo-Martins' response, I thought that was a point that he needed to actually start with. Do you actually have this provision in your contract? So Ngo-Martins, over to you.
Yeah, thank you, Mrs. Makinde. I think it's a very good question. When you do not have force majeure, I think the alternative option for you, at least from a common law perspective, which is what applies in Nigeria, is to consider whether frustration applies. And that's also, so basically, it doesn't necessarily mean that when there is no contractual force majeure, you have no legal, there's no option available to you. Under the law, based on the doctrine of frustration, which is a doctrine, it may well be that in such scenario, you may be able to rely on the doctrine of frustration. I mean, for the legal test for frustration is basically, again, it goes to the court will want to see whether the contract has been impacted in such a way that it's radically different from what was envisaged. The court would also want to see whether there is impossibility in performance as well. And what this effectively means is that once the court examines it vis-a-vis the factual context of your case, what basically happens is that it automatically discharges performance. So I mean, the point to note basically is frustration is a very, very high threshold. Is a very high threshold. So the court will want to look at the impact. And in the context of the question itself, which is pandemic, so the question would be, what's the context? How has it impacted your obligation under the contract? Has it impacted it in such a way that it becomes radically different from what was envisaged? I mean, what we saw during the pandemic basically was that the pandemic effectively was temporal. In which case, sorry, let me rephrase. What basically the effect in terms of the intervention as a consequences of the pandemic, as it affected business, was temporal in the sense that the regulation shutting down business was only for a period of time. And also the regulation regarding return to work basically was such that you could do so subject to your compliance with the social distancing obligations and all whatnot. Once you maintain the social distancing requirements and there are proper health and safety measures in place, you could potentially resume work after the shutdown was lifted. So it is in the context of all these scenarios, the court will look at it in the context vis-a-vis the obligation to know whether it's such that performance was prevented in such a way or that the contract had become radically different. In such case, that would basically inform how it goes one way or the other. But I think the short answer to your question is there is a potential remedy in the context of frustration, but you then need to look at it to determine whether it will apply in the context of your situation.
Dolapo, you are muted.
Okay, sorry about that. Before we move to the next question, I would like to recognize two special people who are here as well. Mrs. Mojisola Gabar, she is the chairperson of the National Association of Microfinance Banks, Lagos Chapter, NAMBLAC, and Mrs. Bumi Lawson. Happens to be my former boss and now the MD CEO of Accion Microfinance Bank. Thank you for joining us today. Daniels, hello everyone. Sincere appreciation to Mrs. Nike James on her sound lecture on stamp duty. I would like to ask, does this mean that we as MFBs need to start charging stamp duty on cash deposits by customers across all accounts? Again, do we charge stamp duty adding to the pre-existing transfer charges on NIP for electronic transfers?
Okay, thank you, Dolapo. The short answer to that is yes. Currently, microfinance banks are not excluded from stamp duties charges. And well, it's unfortunate because given financial inclusion and the class of customers we have, that it would have been a considerate thing if we had some exemption. So until there is an exemption that is given on all cash deposits in all accounts or transfers into customers' accounts that exceed 10,000 Naira threshold, then 50 Naira stamp duties would have to be charged. And it's in addition to all other charges that apply. So it's the receiving account that bears the burden of the stamp duties charge. Thank you.
Thank you, Nike James. The next question, does it mean stamp duty involves loan transactions? And does the clause need to be enshrined in the terms before it can be enforced?
I think Oghogho needs to help us with that.
It doesn't, the clause does not need to be enshrined in the agreement because it is a legal obligation. But the only thing that we would typically say, also for some large ticket transactions, is that parties can actually contractually agree who would pay the tax. Although the FRS order had said that is the paying party, for instance, on the lease issue. The fact is, parties can contractually agree on who would bear a liability or an obligation. The taxman is not interested in who pays it so long as they get that money. So it is not something that you can agree in stay in an agreement. If it's not in my agreement, we don't have to pay it. It is legal and it needs to be paid.
Okay.
Thank you.
Thank you, Oghogho. Now, the next question is for Oghogho as well. From Oghogho Makinde's presentation, there appears to be some conflicts between the provisions of the Finance Act and the Stamp Duty Act. Which of these acts is superior to the other for us as MFBs to rely on, majorly with respect to the collection of stamp duties?
Was that my presentation or Nike's presentation? But if there's a discrepancy between the Finance Act and the Stamp Duties Act, the Finance Act comes after the Stamp Duties Act and is a clarification and amends certain of its provisions. So the Finance Act to that extent would apply.
Okay.
Ngo-Martins, do you want to come in here?
Well, I mean, again, I agree with you, Mrs. Makinde. I mean, essentially, it will depend on the wording of the statute itself. So, I mean, for there to be an amendment, that must be clear in the statute itself that is seeking to make an amendment. So, if the wordings, if the relevant provisions in the Finance Act was such that it was expressly clear that that the intention was to amend provisions of the Stamp Duties Act, then of course, then obviously that would mean that the Finance Act in that context would trump whatever provision is contained in the Stamp Duties Act.
Okay,
I think on the legal side, I think what the legal principle is that the courts would typically interpret these provisions, particularly taxing and fining provisions, very strictly. So if there is a discrepancy or uncertainty, they would typically interpret it in favor of the party that is being penalized. Please, sorry, Nike.
Okay, thanks. I just wanted to add that I'm not sure I said there's a conflict between the Finance Act and the Stamp Duties Act, because the Finance Act has amended the Stamp Duties Act. Where I said there's a conflict is between the provisions of Stamp Duties Act and the JTB Harmonization Schedule, which is not a legislative instrument. So there's no, I don't think there's any controversy. The Finance Act has amended it, and as the lawyers have explained, that is the superior legislation to bear in mind. Thank you.
Okay, thank you very much. Adegbami has a question. Adegoke, please go ahead with your question.
Okay, thank you very much, Ma. My question is on this stamp duty on deposit. I'm seeking a clarification. Is it on deposit or on payment? Because I remember that before now, I had a serious battle with some of our correspondent banks. And what was confirmed is that it's only on third-party payments. But from the explanation today, it suggests to me that if I'm running a savings account and I deposit 15,000 into my savings account, I will pay stamp duty on it. So I want that clarification. My second question is, as a microfinance bank, I have people take loan from me who make payments for their loan through correspondent bank. Naturally, if I have branches all across, that money is supposed to come to my bank straight to their account. But correspondent bank, they act like collection bank. Now, do I exempt that? Or if somebody pays me 15,000 or 20,000 naira repayment, I'll take stamp duty there. And if I do, who pays the balance? Or I need to include a clause in my loan agreement that when you pay through a correspondent bank, make provision for stamp duty. Thank you.
Thank you, Mr. Adegbami.
Okay, thank you for that question. And you know, the good thing about these sessions too is that we get to understand more your business, and then we can see how the law applies, and then the gray areas, we see what to do about it. So on the first issue of, is it on deposit or on payment? I think the law is clear, and the Finance Act is further clearer than the CBN provisions that was previously. That is on deposit. So all deposits that enters into an account is liable to stamp duties at 50 naira, and is the obligation of the receiving account. And the way it is, what people have asked, that what if it's not an electronic payment? It wasn't a transfer. What if I walk into the bank and I deposited it? I think with the language you have now with the Finance Act, even if you deposit money into your account, as you walk into the bank and you pay cash, then stamp duties is going to apply. So maybe that's the first thing to put on the table. Now, in terms of this correspondent bank arrangement, I think we need to keep understanding it further. And I looked through one of the clarifications or explanations somebody gave earlier on, in terms of if I need to transfer money from my bank, or maybe I have an account with a microfinance bank and I want to transfer into another bank I have, maybe it's one of the other major banks, and that's of course that most microfinance banks will use a correspondent bank. So with stamp duties apply. And as I think about it, based on earlier comment also, it should not, because then when a correspondent bank receives it, the correspondent bank is receiving it for the purpose of transferring. It's probably, we really can't treat the correspondent bank receiving it as if it's its own bank account. It is performing a service. It's receiving it for what it is a bank meant to do. But we can check on that for that, but we don't believe that that correspondent bank would have a charge of stamp duties. So if
the law is just not clear. The law is just not specific, sadly, and really it needs to be. We have a concern as well on escrows, for instance. You guys do escrows as well, so you hold amounts on escrow. I think that there needs to be more certainty.
Absolutely. And in some of the earlier discussions we've had with banks, maybe correspondent didn't come up, but they have things like transit account, intermediary. We had noted it as part of the things that needs to be taken forward for clarity. So correspondent
escrows.
And escrows. Okay, thank you very much.
Please add escrows.
Yeah. So correspondent banks too will be one of those areas that will need to get further certainty on and clarity. And obviously FRS in coming out with the Stamp Duties Act is not out of knowledge of how banking transactions work. So it's simply a simplistic way that they have. So if you take it in the most simplistic elements, it would almost seem like, yes, every account should, but I think a case can be made for some of those accounts. So it will be something we'll be happy to take forward and then see what we can come back with around that.
I just think it's astonishing that the FRS takes such a simplistic way, because the economy is so much more sophisticated and they know all of the transactions that they see across the board. It just has not been a deep thought process.
Absolutely. And on the Finance Act, I'm aware there was a lot of, how do you say it? There was a lot of seeking opinion, and a number of we consultants worked with them on a number of those transactions. But on stamp duties, I'm not aware they sought consultation on it. But on the other areas, we put in our comments, we put in our opinion. We had meetings with the Ministry of Finance, FRS, and we were successful in getting a number of those issues through. For instance, even for the microfinance bank, the issue of VAT and what have you, the exemption, all those came in, but stamp duties was not discussed. So that is one of the disadvantages when they use a silo mentality, and it's going to be a law that will create a whole lot of issues. Yeah,
it's very revenue driven, and now there are a couple of embarrassing workbacks, which is not good.
Absolutely.
Thank you very much. The next question is, what options do companies have given the FIRS stance on the 1% for general agreements vis-a-vis the Stamp Duties Act?
Should I take a stab at? Okay, please go on.
Please go ahead, Oghogho, please go ahead, please.
No, I'm just looking at this purely from a legal stand. Challenge. You shouldn't allow a cost that should be borne by your business or by your family or by yourself to be imposed upon you. I know people are concerned about the cost of even challenging, but the fact of the matter is this is not going to go away unless people challenge it.
Absolutely. So we think we shouldn't rest on our auras, and we should use associations like NAM and other big bodies to actually push back until there is a law change that actually legitimizes the 1% on contracts. Today, it is not a legitimate charge, and we should not abide by it. We should push back on it. Absolutely.
It is lawmaking without going to the legislature.
The next question is, can one claim force majeure on the stamp duty charge, given the poverty level of most borrowers at this time? Government should exempt MFBs just as it's done with some services for from VAT.
That's an interesting question. I think the point is force majeure is a contractual provision. The obligation to pay stamp duty is a statutory obligation imposed on parties by law. So I mean, these are two different separate regimes that do not meet. So so I think the simple question to that answer is no. Once there are stamp duty obligations and there are basis to challenge those stamp duties that have been imposed. I think the options that Mrs. James and Mrs. Makinde had suggested, which are options around advocacy and potentially challenging back-end stamp duties that have been imposed illegally. Those are options that are available to parties. But I mean, you cannot declare force majeure on a tax obligation.
On the general level, just to say that taxing laws are usually impersonal, and that is good. It's actually a global principle because you do not want to now start cutting and carving it up. Any cutting and carving has to be done by law and not done in an ad hoc manner. Otherwise, then it may actually be unfair on other people. So the advocacy, we cannot emphasize it enough.
Thank you very, very much. The poll will be going up shortly. Kindly select the correct answers to the questions. And I would also like to reach out to Mrs. Yinka Edu to throw more light on the two topics we've been discussing today. Do you have anything to add to what has been discussed so far?
Are you throwing her under the train?
No, not at all. Mrs. Edu, are you still with us?
I'm sorry, I think you actually are throwing me under the train. I was picking up a call and I just heard my name.
I was trying to be your lawyer.
Please, Oghogho, be my lawyer. Answer for me.
Okay.
Is Oghogho answering for me?
No, sorry.
Oghogho, you need to help out. Answer for her.
Yeah, the question.
Basically, we just want your additional input to what has been discussed today. Anything else to add to what Nika and Oghogho have contributed so far to the
No, not really.
Ngo-Martins?
No, I think that honestly, I think they've covered the issues well. I think that it's extremely topical. The issues, the questions keep coming. I think that this is a great initiative because you're facing the issues and getting clarification. But I think even in many industries, it's an issue that's ongoing. The distinction between force majeure and frustration is something that people need to sort of look at and consider, because even if you don't have your force majeure clause, if the contract is completely frustrated, it's impossible to perform, then at least you can rely on that. And I think it's important for people to understand these legal issues and seek to use that frame to look at the position they're currently in. Stamp duty is an ongoing discussion. It's ongoing. I think we all have to work together to see if we can sort of provide clarity. And I think also it's important for government to get a bit of pushback sometimes so that these things are a little more thought through before they publish and announce. So that's what I want to say. I think in terms of specifics, your real subject matter experts have done a great job of it. Thank you.
Thank you very much, Mrs. Edu. We appreciate. The last question I have here is from Abdullahi Issa from Kano Poly. He says, is force majeure clause agreed upon mutually by the bank and the customer before taking effect in the offer letter? Well, I'm not aware that borrowers like putting force majeure clauses in loan documentation. But I would
advise against it.
Exactly.
I would advise against it.
And the second question is does the customer have a right to invoke force majeure against the bank?
Yeah.
If there is, sorry, please go on, Ngo-Martins.
Mrs. Makinde, you could, okay. I think these questions, these are questions that have been dealt with, which is effectively whether in a loan context, like I said previously, in my experience, in a loan context, you do not have force majeure in loan obligations. And also the question about whether that should happen going forward, I don't think so. I think it's dangerous and would advise against it. So it shouldn't be a clause that is being negotiated between the parties. Where you have a service contract between a bank and its service providers, yes, you can have force majeure in the context of those clauses. Typically, but those clauses are clauses that will be negotiated between the parties, and basically, and some of the points I mentioned in the course of my presentation, which potentially going forward needs to be considered during the context of negotiation, may be useful. So for instance, you want to ensure that in order to avoid situations like what we have seen when the pandemic, with the pandemic, you want to ensure that you have pandemics listed in your list of events, laundry list of events as in your force majeure clause, so that option is clearly available to a party during such context. You also want to ensure, I think it's useful to consider clarifying if you have if you have a force majeure clause that says that where performance is prevented, you may want to clarify it, especially if the nature of the service is such that can be performed remotely, so that is clear in your force majeure clause and it wouldn't amount to impossibility. So yes, I mean, in the context of service contract, those force majeure clauses could be negotiated between the parties.
Okay, thank you very much for that. We'll be relaunching the poll again. Please select your questions and we'll be wrapping up very shortly. Mr. Bayo Gumbanjo has a question and he'll be unmuted to
Yeah, good afternoon. Thank you very much, ma.
Welcome,
I just
Mr.
want to, thank you very much, ma. I just want to make a little clarification on the issue of double charge if a customer has been debited with stamp charge at your correspondent banks. I don't think that will amount to double charge. But when you are doing your reconciliation, instead of you putting the 15 naira charge at your correspondent banks to your profit or loss, definitely you have to debit that customer and state it there that it has to do with the stamp duty. So it is only one single charge. So it's just the accounting wise I'm trying to clarify here. So it doesn't amount to double charge. That's my contribution. Thank you.
Thank you for that contribution. We've noted it. Like we said on the issue of correspondent banks, yeah, there are some things might be valid, some may not. So we'll take all the issues around it together, and we'll hope as we do further engagement on matters of this nature, we can also get full clarity. So thank you for that contribution.
At this point, I will hand over to the MD CEO, Mr. Taiwo Joda, to give the closing remarks. Thank you. Mr. Joda.
Thank you very much, Dolapo. Great job. Thanks, everybody, for coming and staying true. I mean, something keeps coming out very clearly from the discussion we've had since yesterday, and that is the need for a very strong collaborative effort from our association, that is the National Microfinance Bank. And I'm very happy we have a new set of executives that are very vibrant and that are forward-looking, who can push the association forward. So this is another call, a very strong call and appeal that we need to be very deliberate so that all the gains of financial inclusion is not rolled back. Just about a couple of months back, government was distributing money to the poor through the Accion Microfinance Bank. And a few months after, they're using another hand to collect back the money because they are broke. So we really need to know whether we're just paying lip service to financial inclusion, or this is just an attempt to further impoverish the poor that is amongst us. And that is the position we should take as an association, to get clarity and not to create additional burden. To Mr. Ngo, Mr. Ngo-Martins, Mrs. Makinde, Nika James, and Yinka Edo, I want to say a very big thank you for making yourself available and for doing justice to this topic. I want to say a big thank you also to all my colleagues across the association, both from the north, it says people calling in from Kano, Kaduna, and this just shows that we're developing capacity and we're gradually becoming a force to be reckoned with in the financial industry. On August 12th, and notices will be going out, we have concluded arrangement to bring the executive director and of FBN Capital, Mr. Falabi Olorode, and of course, the MD and the Chief Operations Officer of Development Bank of Nigeria to come and discuss issues surrounding liquidity and capital raising. That's going to be Wednesday, August 12th. The FBN Quest representatives and the Development Bank of Nigeria representatives will be here to discuss on the challenges of raising capital for the microfinance institution. And of course, we have our own Adegbani Adegoke moderating that session. I want to thank you again and say Baraka the Salah. And like it's become very popular now, stay calm. Mommy, stay calm. So to everybody, I just say, please stay calm. God bless you. Have a beautiful day.
Thank you.
Thank you. Thank you very much.
Thank you.
Thank you very much.
Thank you, Dolapo. Thank you for having us. Thank you.
Stay calm.
We'll try.
Ina son iya karɓar kuɗin Accion Bank na yi amfani kai kara kasuwa ta.
Chai, Accion Bank will put on the ATM card.
No need to stress, I don't need the stress. With Accion Microfinance Bank, I tell with the best, I no settle for less. With shaking the money, you fit open account. Save money now to pay your bills. And you fit to get the loan to grow your business. Well, my future is bright, oh. My future is bright, oh. With Accion Bank. With Accion, oh. My future is bright, oh. With Accion Bank. With Accion, oh. My future is bright, oh. With Accion Bank. With Accion, oh. My future is bright, oh. Is bright, oh.
Accion Microfinance Bank. My future is bright.
Hey, Accion. Star 572 hash. Na the code. Accion. Star 572 honey go. Open account with Accion to save for tomorrow. There's an easy way to bank every day. Hey, Star 572 hash. Now here we go. I know get wahala. Oh, it's a life. Oh, money on me go. Partners on top your phone, wherever you are, whatever you do, hey, pay your bills and recharge your phone.
Accion Bank we kugo phone. Piano star 572 hash.
Ṣe ìyọnu láti lọ sí ilé ìfowópamọ́ ìwọ ṣáà ti tẹ star 572 hash lórí ẹ̀rọ ìbánisọ̀rọ̀ rẹ.
Accion Microfinance Bank. My future is bright.
Nítòótọ́, ṣé pé tí mo bá ṣí àkáǹtì pẹ̀lú Accion wá máa máyé rọrùn fún mi?
Ina son iya karɓar kuɗin Accion Bank na yi amfani kai kara kasuwa ta.
Chai, Accion Bank will put on the ATM card.
No need to stress, I don't need the stress. With Accion Microfinance Bank, I tell with the best, I no settle for less. Bank where they make it life better. With shaking the money, you fit open account. Save money now to pay your bills. And you fit to get the loan to grow your business. Well, my future is bright, oh. My future is bright, oh. With Accion Bank. With Accion, oh. My future is bright, oh. With Accion Bank. With Accion, oh. My future is bright, oh. With Accion Bank. With Accion, oh. My future is bright, oh. Is bright, oh.
Accion Microfinance Bank. My future is bright.
Hey, Accion, star 572